here this morning on the Attorney General's petition for an advisory opinion on the adult personal use of marijuana amendment. I'll speak first for the Attorney General. I'm joined by counsel for the Florida Chamber of Commerce, Sam Salario, and we will split our time and are each requesting 2 minutes for rebuttal. And then you'll also hear from Mr. Bash for the sponsor.
All right, let me set the scene here. This is a Florida Supreme Court hearing on a proposed amendment for adult personal marijuana use. And right when the attorney begins his argument, the court stops him almost immediately. Watch this opening moment, and then we will look at how quickly the justice shifts into a real debate.
How do you read those words to be a promise?
Because the word allows, Your Honor, suggests, like with the very first line, allows people over 21 to possess marijuana, that there would be, in fact, as a direct result of the amendment, other state licensed entities.
I guess my question, though, is the words are "and other state licensed entities."
Right.
I don't see help me understand what is promised as a result of those words. What will happen? What is the promise that the voter, you say, is misled by?
What the summary suggests is that post-ratification, there will be an availability of licenses for these other state licensed entities that are not.
So you're saying if the words were "and such other entities as the state may license," you'd have no problem with that language?
That would be less problematic, although I do think it's worth noting that, as we say in our brief, that really is not even the effect of the proposed amendment, because all that the proposed amendment would do, it doesn't change anything about existing Florida law or about existing Article 10, Section 29. Today, if the legislature wanted to, it could provide that additional licensure as a matter of its ordinary police powers, and because Article 10, Section 29 right now allows consistent legislation. And I think what's really going on here is that the ballot summary is playing on a desire of voters to see greater competition in this marketplace, because there have been public complaints that the marketplace is monopolized and thereby raising prices. And so voters, at least some voters, may well find it to be significant that there will now be an availability of other licenses, when in fact we know that that's really not what will happen. To the extent that this proposed amendment has any effect at all, it would only be in allowing these other entities that would like to be licensed to go and lobby the legislature. And then the legislature would have to decide if the licenses should exist. And I'd like to highlight two.
I'm sorry to interrupt you, though, but so it seems like I agree with you that in one sense you could argue that in the substantive language here itself, not in the summary, that this thing about allowing the legislature to license entities isn't really doing any work. But I mean, it seems like in the absence of something like that, in a future case, if the legislature did try to do that, someone would inevitably come in and say, this talks, the amendment talked about the medical marijuana treatment centers, and therefore this was meant to be kind of a comprehensive thing, and by negative implication, no one else can do it. So it seems like it wasn't an unreasonable choice to put that in the substantive part of this itself. And so to then expect the sponsors to go into this kind of convoluted explanation in the summary, given that the baseline here is, chief purpose is the target, it just seems like I don't know how reasonable that is.
You can see exactly how sharp this exchange gets. The justice doesn't waste any time. They go directly to the precision of the ballot language, and that attorney has to do this dance between what the amendment says versus how voters might interpret it. This is where the court decides whether a proposal is clear, misleading, or even constitutional.
Chief Justice Muniz, one way or another, there's a problem with the ballot summary. Because it is saying that the amendment itself does the allowing, when that's not at all what's going on. I think what they could have said that would have been less problematic is simply that the proposed amendment would preserve the legislature's pre-existing authority. So at a minimum,
that's getting really. And I understand if we're having kind of a super lawyerly discussion about it, I understand that. But we're talking about, a ballot summary, 75 words, chief purpose, material, material effects have to be disclosed. I mean, if you read it literally, what it's telling people is that there might be two entities in the state licensed other than these medical marijuana treatment centers that, if you want to read it literally and ask, what is this telling people? I mean, is that really relevant to the overall competitive landscape? There could be two, there could be 1,000, but you know what I'm saying? If we're going to parse it like that, isn't that really what we're talking about?
Well, we don't understand the word allows that way. So look at context. That first sentence of the ballot summary is quite clear that the amendment would, and we think this is misleading, but it says that it would allow the possession and use of marijuana. The recreational possession and use. Allows is being understood by voters in a very particular way in the context of this ballot summary, that the amendment itself would generate some rights, including the right to apply for licensure, I think most reasonable voters would assume. But I'll just highlight two cases and then move to our next argument. In 2021 and 2020, the court decided a couple of cases that I think are very similar to here. In 2021, it was the regulate marijuana like alcohol case. The ballot summary there spoke in terms of the amendment regulating for limited use, recreational marijuana for limited use. And so the court asked, well, is there anything in the proposed amendment itself that actually imposes a limit on the use? And of course there wasn't, and so the court found that the ballot summary was misleading. And similarly, in the competitive energy market case the year before that Regulate relied on, the court found that language in a ballot summary purporting to create a right to sell electricity back to the grid was misleading because at most what the amendment would do would not limit a right to sell energy back. And it would just leave it to the legislature to decide whether to create that right. And I think that's more or less on all fours here, because what this amendment would actually do would simply leave it to the legislature to decide the licensure point.
Can you tell me though, I mean, can you just sort of quickly, and I know you want to get to your other stuff, but just quickly walk through the thought process of a voter to whom this distinction that you're raising would be material? So I'm in there, and and I think the idea of allowing recreational use is good, but I would vote no because the legislature might not authorize entities other than MMTCs to sell. I mean, who are you trying to protect?
Well, I think that section 101.161 is clear, that we need clear and unambiguous language. And so even if I can't necessarily identify the hypothetical voter, I still think if a voter would believe the contrary of what the amendment actually does, that's reason enough alone, even if maybe it's not necessarily changing everybody's vote. But I do think probably there's some subset of voters that's sort of apathetic about recreational marijuana use, has no interest in using it themselves, but they would like to see more competition in the marketplace. And so they'll support it under the idea that this will lower prices. They oppose monopolies, and so they want.
If you want more real courtroom moments and breakdowns just like this, stay tuned. I'll cover these cases with the same calm, clear analysis. I will see you on the next one.